The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. Today, we welcome everyone here for this hearing entitled Artificial Intelligence and Intellectual Property, Part 2. That's because Part 1 was Nashville, and Nashville is not the only center of great intellectual property creation. I think Mr. Schiff and I, as Californians and some others, would certainly be the first to say that. I now recognize myself for an official opening statement. This subcommittee has been at the forefront of intellectual property protection for decades. In fact, we are entrusted with that protection by the Constitution, and as one of the oldest committees of the Congress, we take that seriously. For all of those who have been involved in AI, they recognize it isn't new. And the problems of AI are not new. But just as Moore's law created an acceleration of processing power and speed, regenerative AI is doing that before our very eyes today. So today we will be focusing on what has been with us for a long time, problems that have been created, unsolved and untreated, that must be treated sooner rather than later. We also will recognize that there is already a disparity in laws between states. Some of those laws are models for the federal government to adapt. Others may in fact be ones in which the federal government needs to intervene to create a stable and productive platform for copyright. Copyright and trademark do not exist as rights, even though we call them intellectual property rights. They are inducements. They are a balancing act. And I always remind people that that balancing act and that inducement must from time to time be checked to find, are we in fact rewarding the creators of intellectual property sufficiently? Are we protecting the rights that come from that inducement in a way in which one creator does not find themselves at a disadvantage to another creator? Many people view themselves as creators of intellectual property. More than 20 years ago, before another committee of Congress, a former congressman came in and proudly showed us a CD that he had created and given more than 100 as Christmas presents for. It was, in fact, the works of half a dozen different artists in a unique way. And he said, this doesn't exist anywhere else. I created this. There was not one new song. They simply were put onto a CD in a very interesting way. There wasn't even a voiceover from the congressman. I sat in that committee hearing before Energy and Commerce, and in fact, saw heads nodding, saying, well, yes, you created something. He no more created something than, in fact, if the perfect likeness of any performing artist were simply taken and used again. That's not to say that a cover band doesn't have the ability to perform with the attempt to entertain, but it does mean that AI has an unlimited ability to duplicate, and we today will, in fact, be dealing with that question. A vivid example are deep fakes. Deep fakes are clearly abuses of AI that raise the question of whether AI technology can be used to spread misinformation. That's not a question any longer. It's been answered. The question is, will we protect celebrities from deep fakes? Will we, in fact, protect politicians from appearing to say something even worse than what we say in real life? I knew that would be a crowd pleaser. Fundamentally, what AI does is it does perfectly, or can do perfectly, that which we have mimicked for generations. Most great lasting pieces of music are in fact passed down from generation to generation, and before they were passed down in writing, they were passed down by performers in front of each other, teaching the next generation how to do something. So there's nothing wrong with that continuity. but the continuity that's created by man has already been legislated in a way to protect for 70 years past the life of that creator. That is not the case today under AI. It is critical that the development of the technology be ethical and not harmful. Ethical and not harmful is a standard that we believe can be achieved, but it's going to have to also be uniform within the United States, and the United States must lead the world in that ethical and not harmful. Not only is it important for the economy, but it's important for American technology leadership. It's not just about the copyright holders of today and those who will generate new copyright with the assistance of AI. It's about whether America will lead the world into a greater efficiency using AI and, quite frankly, more things that please, that amuse, that in fact do what entertainers, artists, writers have done for thousands of years. This also includes a respect for the freedom that we enjoy in our system. Our very Constitution was, in fact, a plagiarism of great ideas of the past, but it was put together in an original way that has sustained us for 200 years. There will be other hearings. Other hearings that, in fact, will deal with the impact to patents and others. There will be others that will deal directly with trademarks. There will be others that deal with other parts of intellectual property. But today, I think we're going to focus on our witnesses and what they can show us has happened to them in real life and what we can do about it. And with that, I just want to take a moment and give us all a reflection on one of my favorite artists of the past. And so could we present my friend and a man I actually saw in concert.
Hello, I'm not Johnny Cash. I'm a Barbie girl in a Barbie world. Life in plastic, it's fantastic. You can brush my hair, undress me everywhere. Oh, come on, Barbie, let's go party, 'cause I'm in a Barbie world.
I'm sure you'll all see that again in days to come. Our challenge is to make sure that if somebody wants to make something that the late Johnny Cash didn't make and couldn't make because it wasn't even available, if you will, with the new Barbie movie, that his estate for that likeness be properly compensated. That will be one of the questions for today. And with that, I recognize the ranking member for his opening statement.
Thank you, Mr. Chairman, for calling this important hearing today. Thank you for that visual demonstration of why it's important that we're here today.
And you can pick your star when you've got the gavel, too, my friend.
Well, you've set the template, so I like it. And I thank you for hosting the subcommittee out here in Los Angeles, taking our show on the road. This is the mecca of artistry and creativity, culture, and as well as economic vitality. And also, this hearing could not come at a better time on a weekend where the music industry is set to celebrate the best and the brightest, the up-and-comers and the living legends. We are here to examine how current laws and future legislation can protect creators from misuse of a technology that is poised to transform the world as we know it. Drake and The Weeknd didn't collaborate to produce Heart on My Sleeve, and President Biden didn't record a robocall telling the New Hampshire Democrats not to vote in their primary, and Tom Hanks did not appear in a video endorsing a dental plan. They didn't have to. Using generative artificial intelligence or generative AI, a lay person can manipulate an individual's image, likeness, or voice to produce novel content without the subject's knowledge or consent. Altering voices and manipulating images is nothing new, but creating new material indistinguishable from reality is. Because of these technological advancements, 2024 will be the first AI presidential election where deepfakes and misinformation will have the power to deceive voters, making an abnormally consequential election even more consequential and controversial. Abuse of women through the creation of explicit images with generative AI is already a problem, and if you don't believe me, ask Taylor Swift about that. And consumer fraud and other criminality accomplished through the replication of loved ones' voices is no longer an esoteric law school hypothetical. Beyond the parade of horribles, generative AI poses unique challenges to the creative industries in which AI has the potential to create an even larger gap between the haves and the have-nots. Aspiring singers, songwriters, and musicians move to cities like Atlanta, where I'm from, every day in the hopes of breaking into the music industry. These individuals, including many who become my constituents, often work multiple jobs while they pursue their dream of being able to make a living wage based on their creative talents alone. Between COVID shutdowns of concert venues and increased cost of living, artists in my district already feel their dream is even farther out of reach. Misuse of generative AI technologies could compound that problem. For example, copyright laws protect an aspiring singer from having her work performed without compensation, but that copyright does not necessarily extend to the sound of her voice. AI can create an original background track in her voice simply by ingesting previous recordings without her knowledge, without her consent, and certainly without compensation. Our question today is not if, but how Congress should act to protect artists from such treatment. It is our responsibility as legislators to ensure that the creators who enrich our society with their talent and work are able to live and thrive in the age of AI. Many states protect our right of publicity, but no such right exists at the federal level. I'm looking forward to hearing from our witnesses how they believe the current system is working and what protections coming out of Congress should look like. Finally, I recognize that change is not something we can ignore. We cannot legislate a perpetual here and now into existence, and we should not want to. In addition to the profound medical, business, and therapeutic advancements offered by AI, the creative industries themselves have already benefited from the incorporation of AI into their artistry and business models. Indeed, that same aspiring singer can experiment and create new works without the resource-intensive equipment and studio time needed just a few years ago. I thank the chairman again for holding this important hearing. I thank the witnesses for their time. I thank you all for attending this consequential hearing, and I yield back.
I thank the gentleman. Seeing no other opening statements by chairman or ranking member, without objection, all opening statements will be included in the record. It's now my pleasure to introduce our distinguished panel of witnesses. First, Ms. Wilson is a singer, songwriter, and actor who show I watch regularly. She is the reigning Country Music Association Entertainer of the Year and Female Vocalist of the Year, as well as Academy of Country Music Female Artist of the Year. This Sunday, Ms. Wilson will be in the running for not one, but 2 additional Grammy Awards, including Best Country Music Album. In addition to her successful music career, Ms. Wilson has appeared most recently and seasons of the hit show, again mentioned, Yellowstone, which, quite frankly, is in the tradition. Maybe I'll stay off of that. Thank you for being here. Next, we have Mr. Harvey Mason, Jr. Mr. Mason is President and CEO of the Recording Academy, the world's leading society of music professionals, which is best known for putting on the Grammy Awards themselves. Mr. Mason is also a prolific music producer, songwriter, working in numerous artists, including the late Whitney Houston. In addition, he has also appeared and been a mentor and producer of American Idol, The X Factor. Additionally, Mr. Mason is accomplished composer, music director, and director of films, TV, including hits like Sing and the Pitch Perfect movies. Boy, are we lucky to get you here. Next, we have Mr. Christopher Moore. Mr. Moore is president of the Software Information Industry Association, which has a very diversified membership of over 400 companies. Members encompass the very companies who are at the forefront of developing, applying, and innovating AI technology, including the creative industries. His prior role, Mr. Moore served as the industry's senior vice president for intellectual property, and for decades has been an experienced IP professor and professional. Next, we have Professor Jennifer Rothman. Professor Rothman is at the University of Pennsylvania Law School, also holds a faculty appointment at the Annenberg School of Communication. She is I don't talk for a living. She is internationally recognized as an expert in intellectual property, law, rights, and publicity, the right of privacy, and the intersection of such rights, which include constitutional protection of those rights, freedom of speech. Professor Rothman is also an elected member of the American Law Institute. In addition to her JD from the UCLA, Professor Rothman also holds a Master of Fine Arts degree in film production from the University of Southern California, the competitor to UCLA. That's quite a bookend. School of Cinematography. We welcome all of our witnesses, and we're going to begin by doing the mundane but cool thing for the photograph of asking you to rise and take the oath. And if you'd raise your right hand, because it's really good for the picture. Do you solemnly swear or affirm, under penalty of perjury, that the testimony you're about to give will be true and correct to the best of your knowledge, information, and belief, so help you God? Please be seated. Let the record reflect that all witnesses did answer in the affirmative, and we will now begin with an amazing producer of the intellectual property and a victim of AI, Ms. Wilson.
Thank you so much. Chairman Issa, Ranking Member Johnson, and members of the subcommittee, thank you so much for inviting me here today to share my thoughts. I am Lainey Wilson. I am a recording artist, a songwriter, and entertainer. I use my music and my voice to tell stories, to connect to my fans, and to help them to connect to each other. My art is uniquely and literally me, my name, my likeness, my voice. I do not have to tell you how much of a gut punch it is to have your name, your likeness, or your voice ripped from you and used in ways that you could never imagine or would never allow. It is wrong, plain and simple. There aren't many things that we can control in life, but making decisions about the use of our own selves, our own unique qualities, that should be one. I am excited about a lot of ways that artificial intelligence can be used to help people, but I'm nervous about how it can be used to take personal rights. And I'm honored today to represent the Human Artistry Campaign, a coalition of creators and organizations that promote the ethical use of AI, and who understand that human connection is an essential part of our culture that we just cannot put at risk. Many creators have already seen their life's work and their own voices and images thoughtlessly ingested into AI models without their permission. Our identities represent years of work to hone our craft and make a livelihood out of our passion. Our voices and likenesses are indelible parts of us that have enabled us to showcase our talents and grow our audiences, not mere digital kibble for a machine to duplicate without consent. AI tools are purposefully being made to take a lifetime of specific artists' voices and likenesses in a split second. Some creators are okay with AI platforms using their voices and likenesses, and some are not. The important thing is that it should be their choice, and not a choice that an AI cloning company gets to make for them. AI-generated music and video using an artist's unique identity to perform in questionable settings or to sing lyrics that they would never write or express, that does not truly reflect who they are, is unacceptable. It is a personal violation that threatens a person's dignity and can put at risk everything that they have worked so hard to accomplish. An artist's voice and likeness are their property and should not take a backseat to the economic interests of companies that have not invested in or partnered with the artist. I join with many other creators in the Human Artistry Campaign in support of the No AI Fraud Act, and I want to express my deep appreciation to its sponsors. I have heard that some interests have criticized it as preventing freedom of expression that uses the voices and images of other people. I'm a big proponent of free speech, and I'm certainly no lawyer, but I do know that if you take away the ability of artists to express themselves, you are, by definition, limiting freedom of expression. It's not just artists who need protecting. The fans need it too. It's needed for high school girls who have experienced life-altering deep fake porn using their faces, for elderly citizens convinced to hand over their life savings by a vocal clone of their grandchild in trouble. AI increasingly affects every single one of us. And I'm so grateful that you are considering taking action to ensure that these tools are used in a responsible way. I want to thank y'all for your role as guardians of our personal rights. We need artists to keep telling stories and connecting with fans and bringing people together authentically. And we need to keep humanity in art. We cannot lose that. The No AI Fraud Act is a great place to start. Thank you.
Thank you. Mr. Mason.
Thank you. Chairman Issa, Ranking Member Johnson, and members of the subcommittee, thank you for inviting me to testify today on the topic of artificial intelligence. My name is Harvey Mason, Jr. As the CEO of the Recording Academy, I'm happy to welcome you to Los Angeles for Grammy Week, music's biggest week. The Academy celebrates music every year at the Grammy Awards, but we also support music through the year as a membership organization representing thousands of music creators and music professionals. As Chairman Issa said, I too am a music creator. As a songwriter, a producer, I've worked with legends and superstars from Whitney Houston to Beyonce to Elton John to Justin Bieber. Music makers have always embraced technology to innovate. From multi-track recording and the electric guitar to drum machines and synthesizers, there are so many examples of disruptive but really cool technologies that changed how music is made. AI is the latest example of a tool that can expand opportunities for different voices to follow their passion and create new music, and we believe that's a good thing. AI also has many valuable uses outside of the creative process, including those that amplify fan connections, automate efficient payment systems, and more. We embrace these advances, and the Recording Academy is leading by example. This year, the Academy announced a new partnership with IBM that will use generative AI to create customized content before and during the 66th Grammy, implemented by the Academy's editorial team. Through this partnership, we'll be able to feature more insights on Grammy-nominated artists, drive engagement around special moments, and connect millions of music fans to the artists that they love. Importantly, AI will be a tool that our editorial team will use to enhance and expand their work, not replace it. And our team will be involved in everything that is produced, In addition, the AI will be drawing from our own content and our own data with our permission and our oversight. The Recording Academy is in the business of celebrating human excellence and human creativity. That was the biggest concern when we crafted our Grammy Awards policies. We understand that AI is here and it's not going anywhere, but our award guidelines stay true to our mission to honor the people behind the music. Only human creators are eligible to win a Grammy Award. So as we embrace the huge potential of AI, we're also mindful of the risks. And more than any other issue involving AI, the artists and creators I talk to are concerned that there's very little protection for artists who see their own name or likeness or voice used to create AI-generated materials. Artists in every genre have seen their voices mimicked using AI without their permission. Iconic artists who are no longer with us have also had their voices reproduced without the involvement of their families, like you heard today. This misuse hurts artists and their fans alike. Recently, we saw the extreme dark side of AI fakes, as some of the most famous and recognizable artists in the world have been the target of explicit AI-generated images put online. And AI fakes don't just target artists, they impact all of you as well. Before New Hampshire's presidential primary, a robocall impersonating the president discouraged people from voting. While it's not clear if this fake was actually AI, the potential for AI to be used to spread misinformation is obvious and is terrifying. Many issues involving AI are complex, and the path forward is uncertain. But the problem of AI fakes is clear to everyone. Right now, there's a patchwork of state laws that addresses the right of publicity for individuals. These laws are inconsistent with each other and they're out of date, and they do not address the AI problem. Many states don't even have them at all. This is a problem that only Congress can address to protect all Americans. For this reason, the Academy is grateful for the introduction of the No AI Fraud Act, supported by many members of this committee. The bill establishes in federal law that an individual has a personal property right in the use of their image and voice. That's just common sense, and it's long overdue. The bill also empowers individuals to enforce this right against those who facilitate, create, and spread AI frauds without permission. Importantly, the bill balances these new protections with the First Amendment to safeguard speech and innovation. Freedom of expression is essential to the music we create, but it also must include the ability to protect our own individual expression from being misappropriated by others. Last year, the Recording Academy joined other organizations representing all the creative industries to launch the Global Human Artistry Campaign. Today, the campaign includes over 170 organizations in 30 countries. And this morning, the campaign published in an ad in the USA Today featuring the names of hundreds of artists and actors asking Congress to support the No AI Fraud Act. On behalf of the Academy and our over 20,000 members, I too respectfully but strongly ask for your support. Technology has and always will play a part in amplifying creativity, but human creativity is the ultimate expression of creativity. Creative works shape our identity, our values, our worldview. People relate most deeply to works that embody the lived experience, perceptions, and attitudes of others. Thank you very much.
Thank you, Mr. Moore.
Mr. Chairman, Ranking Member Johnson, and members of the committee, it's a privilege to appear in front of you today. My name is Chris Moore, and I am the president of the Software and Information Industry Association, or SIIA. Thank you for this opportunity to share our views on identity in the age of AI. SIIA represents over 350 diverse companies in the business of information. Our members range from startup firms to some of the largest and most recognizable corporations in the world. For over 40 years, we've advocated for the health of the information lifecycle, advancing favorable conditions for its creation, dissemination, and productive use. Our members create educational software and content, e-commerce platforms, legal research and financial databases, and a variety of other products that people depend on in wide swaths of their commercial and everyday lives. We are the place where information and technology meet and sometimes collide. Our members have wholeheartedly embraced the promise of AI to revolutionize information management, creation, analysis, and dissemination. Collectively, they've invested billions in its development, acquisition, and deployment, and are pioneering the use of AI to address myriad social needs in the classroom, in fraud detection, in market data, in money laundering investigations, and in locating missing children. When it comes to policy, SIIA generally advocates for policy solutions that withstand changes in technology. We acknowledge, however, that in some cases, AI is different, and support the adoption of a risk-based framework to regulate these technologies. Our members have been leaders in advancing AI accountability and governance. The reason is simple. AI that generates the most unbiased, accurate, and trustworthy information will be based on reliable data. Respect for and protection of intellectual property is key to our policy mission, and our members rely on the incentives that IP law creates. We've been involved in anti-piracy work for almost 4 decades. We're members of the Copyright Alliance. We believe that the use of AI must comply with existing statutory requirements and respect for established intellectual property rights, which provide crucial incentives to authors, artists, technologists, and scientists to create original works. The use of copyrighted works without permission to train generative artificial intelligence models remains the subject of active litigation, and the legality of its use will be heavily fact-dependent. Our members are confident that the courts will sort out the fair uses from the unfair, and that at this point in time, they are the institution best situated to do so with respect to the copyright law. With that said, we recognize that this is not a copyright hearing, and we recognize the non-copyright harms that misuse and abuse of AI can cause. We're seeing examples in the media of digital replicas used to fool the public or maliciously target an individual. When abused, this technology can cause severe harm to a person's privacy rights, and we commend the committee for examining potential legal remedies. I want to highlight 3 points. First, not all identity-based harms are the same. Many identity-based harms are already covered by different doctrines created by federal and state statutes, and these doctrines already apply to generative AI uses. For example, the law already remedies false celebrity endorsement under the Lanham Act. Second, it's important to consider the limits of the First Amendment. Statutory rights that regulate identity will be reviewed by the courts as a form of speech regulation. In order to survive the heightened scrutiny that such a statute would receive, it's critical that it both be tailored to remedy a specific harm and contain sufficient breathing space for expressive works and other kinds of protected speech. And third, we recognize the harm that generative AI can create for individuals, most notably through the use of sexually explicit deepfakes. The ability to quickly create sexually explicit deepfakes is new. Congress did pass a statute to address this problem as part of the Violence Against Women Act as applied to revenge porn, but its application to deepfakes is at best ambiguous. This is an area where Congress can and should act. Thank you for the opportunity to present our views, and I look forward to your questions.
Thank you, Professor Rothman.
Chairman Issa, Ranking Member Johnson, and members of the subcommittee, I appreciate the opportunity to testify today about artificial intelligence and identity rights. I'm Jennifer Rothman. I am a professor of law at the University of Pennsylvania and have been researching and writing about identity rights and intellectual property for almost 2 decades. You asked me to consider the possibility of a federal right of publicity as well as 2 circulated draft bills. I will focus on 2 primary points taken from my more detailed written statement. First, that although the capabilities of AI are new, the problem of using a person's voice, likeness, or performances without permission is long-standing. We have many laws already on the books that address such unauthorized uses regardless of the technology employed to do so. Accordingly, any federal legislation in this area must improve the current state of affairs and not create or exacerbate problems. Second, any federal right to a person's voice or likeness must not be transferable away from that person. Allowing such transfers violates our most sacred and fundamental rights and thwarts the express goals of legislation addressing AI, many of which have been articulated today, which are to protect the livelihood of performers, the dignity of ordinary people, and the ability to distinguish accurate images and sounds from those which are deceptive. My first point is that current laws already apply to works created by artificial intelligence. From the early 1900s to today, every state that has considered the issue has adopted some form of a right of publicity. None have rejected it. This is a law that restricts others from using another person's identity without permission, including in the context of performances. The concerning examples of AI that have been raised in these and prior hearings all violate these existing laws. Tom Hanks, Drake, The Weeknd, and the various teenagers, such as those in New Jersey, whose images have been used in pornographic images, each have likely successful lawsuits under state publicity laws. Federal copyright law may also be violated in these contexts, and Hanks, Drake, and The Weeknd could bring successful federal false endorsement and trademark claims. In short, there are already robust protections on the books. This means that the bar to enacting something new should be high, and legislation should not destabilize what is working about current laws with hundreds of years of precedent, nor make things worse for performers, athletes, or ordinary people. This leads me to my second point. Any federal intervention in this space must protect self-ownership and ongoing control of one's own identity. No one should own another person. Unfortunately, each of the circulated drafts to address the problems of AI and performance rights essentially do exactly this, including the No AI Fraud Act. They allow another person, or most likely a company, to own or control another person's voice or likeness forever and in any context. It's essential that any right created by federal legislation that protects a person's identity not be transferable away from that person. Imagine a world in which Taylor Swift's first record label obtained rights in perpetuity to young Swift's voice and likeness. The label could then replicate Swift's voice over and over in new songs that she never wrote, and have AI renditions of her perform and endorse the songs in videos, and even have holograms perform them on tour. In fact, under the proposed No AI Fraud Act, the label would be able to sue Swift herself for violating her own right of publicity if she used her voice and likeness to write and record new songs and publicly perform them. This is the topsy-turvy world that the two draft bills would create. This does not serve the interests of current and future recording artists, nor the public more broadly. Allowing another person or entity to own a living human being's likeness or voice in perpetuity violates our fundamental and constitutional right to liberty. We do not allow people to sell themselves into slavery or servitude. We do not allow people to sell their votes or their organs or their babies, and we should not allow people to sell their names, likenesses, or voices. Making publicity rights transferable poses a particular risk to student athletes, children, actors, recording artists, and models. Such transferability also threatens ordinary people who may unwittingly sign over those rights as part of online terms of service. Allowing transferability harms not only the person who loses control of their own identity, but all of us. Owners or licensees of another's identity rights could generate performances by that person forever, making them say and do things they never did. This is a chilling prospect and poses a broad threat to society by undermining trust in authentic communication and seeding misinformation. Accordingly, any federal rights to a person's identity must not be transferable, and there must be significant limits on licensing. Without such limits, these proposed laws will exacerbate rather than combat deception and will fail to protect each of our voices and likenesses. In spite of these concerns, there are some opportunities with federal law in this area, and I discuss these in more detail in my written submission. I look forward to your questions.
Thank you. And you've made it perfect for me to recognize myself for a round of questioning. Professor, under existing law, that very slavery, the ability to sign away your rights, as far as you know, is there any prevention of Ms. Wilson from potentially signing away both her current and future rights, or any other artist under current law?
So under federal law, there's no right. Under federal law, there's no right that allows for that transferability. But I'm saying, is there any prohibition on her signing a document that would say that she's doing it? Well, the state laws, some of them preclude some transferability. For example, Illinois prohibits creditors from getting control over a person's identity if they go into bankruptcy.
Right.
In
Bankruptcy
California,
law does not allow you to lose your future earnings, is what you're saying, and that's federal too.
No, I think that one of the things that's really important for legislation in this area, federal legislation, is not to allow and erect a federal law that allows that transferability. I think that
I couldn't agree with you more, but I asked the question the way I did for a reason, and that, Ms. Wilson, I want to bring it to you. You're now an incredibly accomplished artist. You control your destiny, perhaps at the highest level of any artist because of who you are and where you are, but you earned that from the bottom.
For sure.
Tell us, were the pressures when you were first trying to get that break, were they such that, in fact, those who sign you would, in fact, have asked you to sign away